technical and conforming changes. Pursuant to notice, I call up H.R. 1526, the No Rogue Rulings Act, for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 1526 to amend Title 28, United
Without
States.
objection, the bill will be considered as read and open for amendment at any point. Chair recognizes the gentleman from California, Mr. Issa, for an opening statement.
Thank you, Mr. Chairman. Since the start of President Trump's second term, Democrat activists, with the support of sympathetic judges, have secured nationwide injunctions that have halted the implementation of more than a dozen executive actions and executive orders. The president's actions span critical policy areas that he was elected to address, including immigration, federal spending, regulatory reforms, and the like. Let me be clear, the injunctions are nothing more than partisan judicial overreach and have disrupted the president's ability to carry out his lawful constitutional duty. These nationwide injunctions have been exceptionally broad in scope and apply not only to the parties that sought the injunction in the case, but also to non-parties, meaning unlike class action suits, these are being classed without the creation of a class. This has allowed activist judges to shape national policy across the entire country, sometimes the Constitution never, in something this Constitution never contemplated. No Rogue Rulings Act, or NORA, curbs these overreach by district judges by limiting the scope of the injunctive relief to only those parties before the court, rather than being applied universally. Apply universally being, in the ordinary course of the Constitution, a right of the Supreme Court. By limiting the scope of such injunctions to just parties in a particular case, the bill will prevent any one of nearly 700 judges from making a decision that affects the entire country. The bill will also deter forum shopping because a president's political opponents won't be able to cherry-pick a sympathetic judge who is most likely to go along with blocking the president from nationwide. This change ensures that legal challenges to the executive branch focus on the effect of the actions have on that party in a particular case rather than nationwide political ramifications. Let me be clear. If many parties join in a single action, many parties are present, but certainly not those not present, including throughout the country where they might, in fact, not want such an injunction. In short, NORA restores proper judicial restraint to focus on the effectiveness of the executive actions and actual litigations, and not political preferences by individual judges or interest groups. I want to make one thing clear. These cases behind me and our bill, if the shoe was on the other foot by the time we get done today, I want this to be a piece of legislation that is equally liked or disliked and equally fair, no matter who the next president is. We are not passing a law for the current occupant of the White House. We are passing a law that will improve the effectiveness of the executive branch and the reasonable challenges to actions by an executive branch now and for the rest of the many years of our great republic. I want to thank the chairman for bringing this important legislation to the committee, and I urge support for the bill, and I yield back.
Chairman yields back. I now recognize the ranking member, Mr. Raskin, for his opening statement.
Mr. Chairman, thank you very much. The chart is fascinating because the gentleman seems to imply, if you keep it up, that would be great, because the implication of this chart is that somehow the courts have done something wrong rather than Donald Trump having done something wrong. The reason there are 64 injunctions against him is because he is trampling the lawmaking and spending powers of the Congress of the United States. He's violating the civil service rights of federal workers, and he's betraying the federal law in every particular way. If anything, that chart demonstrates precisely why we need the law to be exactly as it is. The whole purpose of temporary restraining orders and preliminary injunctions is to stop actions by government that are causing irreparable harm, where there is a likelihood of the plaintiff to succeed on the merits of the case. And so the neutral law that my good friend from California is hoping for actually exists right now. This is the way it's always been. And so I don't know how many injunctions there were under Biden. I can't see. Is it 14? Well, I don't know. I don't know exactly what the right number is, but if there were regulations or actions by the government under Biden that met the standards of a temporary restraining order or preliminary injunction, then that is the necessary and proper mechanism of the law. But nobody's seen anything like what Donald Trump has been doing. As Donald Trump told us last night, you might love it, you might hate it, but as he said, it's radically unprecedented for the executive branch of government to go in to try to hollow out the federal government of the United States. So look, from our perspective, when Donald Trump says we're going to freeze all spending that has been appropriated by the Congress of the United States of America, that is a violation of our spending power, right? An Appropriations Act is a federal law, just like the law that says you can't beat up federal officers. An Appropriations Act is a federal law. It's not a budgetary recommendation to the president, and it might be right, it might be wrong, it might be the smartest appropriation in the world, it might be the dumbest appropriation in the world, but it is the appropriation of the Congress of the United States. And so the courts rightfully were saying, no, you have no power just to randomly, arbitrarily, unilaterally, monarchically freeze the spending of the Congress of the United States. We are the lawmaking power. So the gentleman's bill invites us basically to destroy a mechanism which is available to all Americans, and which, by the way, they freely availed themselves of under President Biden. There's a judge in Texas who became famous, although I can't remember his name. Somebody will tell me. Kaczmarek. Judge Kaczmarek, who issued repeated nationwide injunctions to implement a right-wing agenda. The problem there, of course, was forum shopping, court shopping, judge shopping. But if the case had actually been properly before him, and he was properly interpreting the law, which he was not, but it would necessarily lie that it should apply to everybody across the country. I mean, this is like saying in Brown versus Board of Education that the desegregation order should apply only to Linda Brown and the other plaintiffs in the case, as opposed to applying everybody in the country. That just doesn't make any sense. So we're going to oppose this very strongly. The bill is a betrayal of what, in fact, is objective, neutral, procedural mechanisms in the law that are well understood. And if it's unconstitutional for people in New York or Texas or Louisiana or California, it's unconstitutional for everybody in the country if it's a federal policy. Happy to yield back.
Gentleman yields back. The gentleman from California is recognized.
Mr. Chairman, I have an amendment at the desk.
Clerk will report.
Amendment in the nature of a
Without objection, the
substitute.
amendment will be considered as read. The gentleman is recognized to explain his amendment. And consider base text for the purposes.
Thank you, Mr. Chairman. The amendment modifies the title of the bill and makes it more easily understood. It is intended in no way to alter the important purpose of the bill, and I urge support. And I might caveat that we do have a number of amendments on our side that have been carefully worked out that came in by members on our side who were equally concerned at making sure that this bill strikes a balance, not based on how many back and forths there are between who got more, but based on a growing trend of using these, and we believe that when the ranking member and other members on the other side see the amendments, they'll agree that the bill is intended to be balanced and is intended to preserve many of the things that the ranking member is concerned about. So with that, Mr. Chairman, I urge support for the amendment in the nature of a substitute and yield back.
Gentleman yields back. Who seeks recognition? Gentleman from Kansas is recognized.
Thank you, Mr. Chairman, and I have an amendment at the desk.
Amendment to the amendment in the nature of a substitute.
Correct.
All right.
Reserve a point of order, Mr.
Point
Chairman.
of order reserved by the ranking member. The clerk will report.
Amendment to the amendment in the nature of a substitute.
Without objection, the amendment to the amendment in the nature of a substitute will be considered as read. The gentleman from Kansas is recognized to explain his amendment.
Thank you, Mr. Chairman, and I want to thank the sponsor of the bill. I had raised in a much more limited fashion, but certainly some of the concerns that the ranking member has expressed in a much more, much broader fashion. The amendment is intended to provide a safety valve. Pardon me, could I have a drink of something here?
Get some
Excuse
water.
me, Mr. Chairman, is intended to provide a safety valve that provides that balance and makes sure that there is still an appropriate tool available in appropriate cases. With the chart that was discussed earlier, I was counsel to my client, the state of Kansas, on several, though certainly not all of those cases, certainly some of the 12 and some of the 14 during the Obama and Biden years. I might have been during some of the Trump years. I actually don't recall. I haven't gone back and looked at all of them. But representing a state is a different animal from representing a private party. In fact, the Supreme Court has recognized that for some purposes, for example, standing in some of these challenges, not that this is a standing issue, states have special solicitude in defending their role in our federal system. And certainly when the federal government, thank you, takes action, states may have an interest. So this amendment is intended to ensure that that balance remains available. It would provide essentially a carve-out provision that could apply in a limited number of circumstances where the base rule of the underlying bill, which is no nationwide injunctions, except only as to the parties, would apply. And the exception would be available when states are the parties, the plaintiffs, two or more states, in at least 2 circuits, depending on how many states, so that you don't have a parochial localized interest, tends to demonstrate a national interest. In that case, if a nationwide injunction is to be sought, the matter would be heard by a 3-judge panel at the district court level under the ordinary statute that does those things, except we would provide that the appointment of the 3 judges for the panel would be randomized so that you don't have a circumstance where a chief judge, for example, might be tempted or able to handpick judges of a certain philosophy or predisposition. And then it would provide that in the event that a nationwide injunction is either entered or not entered, if it's sought, a party would have the ability to appeal, if they so chose, directly to the Supreme Court. So this is designed to do several things. First of all, to minimize the benefit to plaintiffs of forum shopping, because you aren't certain who your judges are going to be, and to make sure that no single judge is in a position of entering a nationwide injunction that goes beyond the parties on these matters of sort of public policy concern. Second, to make clear that states have a particularized role in some of this federalist litigation as to the federal government. And third, to minimize the ability of litigants to gum up or delay process, which sometimes may be a portion of the strategy here. Just as justice delayed is justice denied, sometimes federal policy delayed can be justice denied. So that's the intent and what the amendment does. Mr. Chairman, I am grateful to Mr. Issa and to others who have worked with us on this at some length. Obviously, as a former state attorney general, I'm particularly sensitive in this area, and I think this cuts both ways. It will allow folks of both parties to use it.
The gentleman yield.
Certainly.
I just want to make sure, I appreciate your work on this, working with the sponsor. I just want to make sure I understand it. Multiple districts, there could be an appeal to a sort of an expedited review to a 3-judge panel with then the ability to appeal to the Supreme Court. Is that how we're, in the limited circumstance you described where it's involving multiple districts and it's action brought by states?
Yes, sir. State plaintiff, multiple state plaintiffs, states plaintiffs from multiple circuits, goes to a 3-judge panel, and has an expedited review potential.
Multiple states,
Court.
multiple circuits, 3-judge panel, expedited review, with then a further review possible to the Supreme Court.
Correct.
All right. I think that, I appreciate
Would the gentleman further yield?
Certainly.
And my understanding in our staffs working together on this so diligently and your personal engagement, you had examples of where it has been a practice to have 3-judge panels when we really do want to make sure that it has the full weight and consideration, and that's what allows for a reasonable appeal directly to the Supreme Court.
Yes, that's correct. The existing statute with respect to 3-judge panels applies in various circumstances. The one that most commonly has arisen in my own experience is with respect to redistricting, but there are others that are provided for by the statute, and then having the direct appeal likewise.
And this, further yielding, this by definition limits the ability of one judge, a rogue judge, well, in fact, not changing the fact that if it's a good decision, 3 judges will reach the same decision.
Absolutely, and that is the intention, to minimize to use the term of the statute, the title of the statute, the potential for a rogue judge, as the bill terms it, while still allowing access when it is truly necessary and appropriate.
Gentleman's time has expired. Appreciate his amendment. The chair now recognizes the ranking member.
Thank you very much, Mr. Chairman, and I thank the gentleman for offering this amendment, which on my standards, it takes an F bill and turns it into a D- bill. So I will support it, but I don't think it gives the bill a passing grade, because when I look at the litigation that's been brought in the first furious 6 weeks of the Trump administration, there have been overwhelming victories against the Trump administration, as the chart helpfully instructs, but only a handful of them come from states. So, for example, there's a win with New Hampshire on the birthright citizenship issue, which of course it was blatantly constitutional to attempt to just nullify birthright citizenship, the very first sentence of the 14th Amendment. And New York versus Donald Trump, which had to do with illegal disclosure of personal and financial records to the DOGE group, the Department of Government Efficiency. So there were wins there, but most of the wins came by individuals. So take, for example, the removal of independent agency leaders in American Federation of Teachers versus Besant, or Dellinger versus Besant. I mean, the vast majority of those being harmed by the Trump-Musk offensive against our Constitution here are individuals. They're people who are beneficiaries of Social Security or Medicare or Medicaid. They are individual workers at the NIH or at the NOAA, the National Weather Service, who are being sacked unilaterally and arbitrarily by the administration and so on. Those people should have equal rights to get into court, and they have interests that are replicated all across the country. So obviously that provision would then channel everything into state litigation in order to have nationwide clarification of what people's rights are. But I just don't see the logic of carving out that exception. I'm willing to vote for it because, again, it makes a really unnecessary and retrograde bill slightly better. But it doesn't solve the basic problem that we're nullifying TROs and preliminary injunctions on a nationwide basis when they apply nationally to people who are being harmed by offensive governmental action. I yield back.
Would the gentleman yield?
Yes, I would.
You know, I might say that if you look at the amendment, the second paragraph, where it says page 1, line 17, that in fact does encourage the formation of a class action so that it would include, if you will, the entire class. But I think the most important thing, and I'll ask it as not as,
if you did interrupt, if I can interrupt for 1 second, maybe we got the wrong amendment because. Oh, this is your amendment, rather?
Yeah.
Oh, gotcha. Okay.
but we're sort of doing two at once as we speak. But, Mr. Ranking Member,
agree to
the rhetorical question I'm asking, and it's not completely rhetorical, is if we look at the allegations made against the current president in these various cases, if the world were as just as it could be and the court was as good as it would be, would it not form a three-judge panel in a matter of days, just as quickly as a single judge, convene, make a decision, and the Supreme Court act in an expedited fashion, so in a very short period of time, uncertainty would be consistently resolved? Wouldn't that be the best case as compared to today, where you may or may not get injunctive relief, and it can be uncertain? You know, what the gentleman, Mr. Schmidt, has done here is he's created, for the most common case, which is states objecting to these actions, he's created, I think, a very clever expedited possibility. It may be a bit of a burden on the Supreme Court, but ultimately these cases get to the Supreme Court, and he has come up with, I think, a good protective way to get to the court quicker. And when the shoe's on the other foot, I know that you're going to love this. The shoe is not really bad today. As you said, D-. You know, I'm a Kent State graduate. That's a passing grade. I'd like a C, but you know, I'm thank you for getting off the F.
Well, but again, I'm going to support his amendment because I do think it makes it marginally better. But to me, it doesn't redeem the whole enterprise, because the system is working, and it's working in a necessary way here. I don't understand our colleagues' determination to try to remove every obstacle to what Donald Trump and Elon Musk want to do, even constitutional obstacles, even legal obstacles. I thought, as the Judiciary Committee, we would really be determined to stick with the law.
The time of the gentleman expired. The question occurs on the amendment offered by the gentleman from the amendment to the amendment in the nature of a substitute. All those in favor say aye. Aye. Those opposed, no. In opinion of the chairs, the ayes have it. The amendment is adopted is added to the amendment in the nature of a substitute. Who seeks recognition? Gentleman from Georgia is recognized.
Mr. Chairman, I have an amendment at the desk.
Clerk will report.
Reserve a point of order.
Point of order reserved by the gentleman from California. Clerk will report the amendment.
Amendment to the
Without
amendment.
objection, the amendment will be considered as read.
I'd object to the waiving of the reading.
Okay, the clerk will read the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1526 offered by Mr. Johnson. Page 1, insert after line 3 the following, and redesignate succeeding sections accordingly. Section 2, findings. Congress finds the following. Since taking office, the Trump administration has sought to tear apart our democratic institutions through unlawful and unconstitutional executive actions. Because federal courts keep ruling against the administration, Republicans in Congress are seeking to change the laws to help the Trump agenda. 2, the court in Casa v. Trump, when imposing injunctive relief, found that, quote, the executive order flouts the plain language of the 14th Amendment to the United States Constitution, conflicts with binding Supreme Court precedent, and runs counter to our nation's 250-year history of citizenship by birth. The president does not have the authority to strip them of their constitutional right to citizenship by birth. 3, the court in National Council of Nonprofits versus OMB, when imposing injunctive relief, found that the, quote, defendant's actions in this case potentially run roughshod over a bulwark of the Constitution by interfering with Congress's appropriation of federal funds, and it attempted to wrest the power of the purse away from the only branch of government entitled to wield it, end quote. 4, the court in Washington v. Trump, when imposing injunctive relief, found that, quote, the United States Constitution exclusively grants the power of the purse to Congress, not the president, and the president does not have unilateral authority to refuse to spend the funds Congress appropriates. The executive order thus amounts to an end run around the separation of powers. Not only has the administration claimed for itself Congress's exclusive spending power, it has also attempted to coup Congress's power to legislate, end quote. 5, and the court in New York v. Trump, when imposing injunctive relief, found that, quote, The executive statement that the executive branch has a duty to align federal spending and action with the will of the American people as expressed through presidential priorities is a constitutionally flawed statement. The executive branch has a duty to align federal spending and action with the will of the people as expressed through congressional appropriations, not through presidential priorities, end quote.
Gentleman's recognized.
Thank you, Mr. Chairman. I thank the clerk for her reading of that. The judicial branch ensures that people, corporations, and even other branches of government follow the law. And if a government entity does something illegal, the only way for the court to prevent thousands of people from being harmed is to order a nationwide injunction that stops the government from doing that illegal thing. It is essential to our democracy that the courts can serve as a check on an executive branch or even a legislative branch that is trampling people's rights. While proponents of the underlying bill say that everyone should bring their own cases, that just doesn't make sense. There is no way that each of the thousands of people harmed could pay for their own lawyer, get into a courtroom, and try their own case. Aside from the difficulty and cost to everyone, our courts could never handle that volume of cases. Their dockets are already bursting at the seams, and justice would be so delayed that it would be denied by default. Plus, that might lead to unfairness and variation if judges one state or one county over rule differently on the same set of facts. It would be inefficient, cost-prohibitive, unfair, and unjust. Republicans only want this bill because federal courts keep ruling against Trump's unlawful and unconstitutional executive actions. Therefore, they are trying to hamstring the courts from stopping him. We need our courts to continue to serve as a bulwark of democracy against the Trump administration's flood of illegal actions. That's why I object to this bill. However, if the bill is to move forward, I believe it should include my proposed findings, relaying the court's vivid language about why the injunctions they are imposing were so necessary and so vital to American democracy. This includes the court's opinion in National Council of Nonprofits versus OMB that the administration's actions, quote, potentially run roughshod over the bulwark of the Constitution, end quote, and that the administration, quote, attempted to wrest the power of the purse away from the only branch of government entitled to wield it, end quote, namely us in the legislature. My findings amendment also includes the court's opinion in Washington v. Trump, stating that the executive order in the case, quote, amounts to an end run around the separation of powers, end quote. This is important information that needs to be a part of the record when we are deciding whether to completely upend the delicate system of checks and balances that has sustained our democracy for nearly 250 years. I hope that you will support my amendment, although I will be voting against the underlying bill. And with that, I yield back.
Will the gentleman yield for 1 second?
I'll yield to the ranking member.
Thank you, Mr. Johnson, and thanks for your thoughtful amendment. It occurs to me that our colleagues would invite this checkerboard approach where you'd have to bring a lawsuit in 50 different states, and then 43 might say, for example, the birthright citizenship executive order is clearly unconstitutional. As one Reagan judge put it, he said it was the easiest case he'd ever had to decide, and you don't need to be a lawyer, you just need to know how to read in order to reject this. But maybe you could get a handful of judges to say, no, it's constitutional. Then you've got this fragmented checkerboard approach. In any event, why not just let it work its way up? And so that we could get a decision by an appeals court and the Supreme Court, rather than going from 46 injunctions, which is what we've got now according to this useful chart, to 46 times 50 injunctions, right? 2,300 injunctions in the country. I mean, that's a total waste of judicial resources and an offense to judicial economy. We yield back.
Gentleman yields back. Gentleman from California is recognized.
Thank you, Mr. Chairman. I'm not reluctant in opposing this amendment. I'm a little surprised at the nature of it. It was kindly I also join in thanking the clerk for reading the full bill. The amendment, as I see it, is best seen as footnotes of opinion as to the bill and not something that would normally be found in a law. So for that reason, the reason that it doesn't really read, it reads like a piece of history, not like an amendment, I'm going to oppose it. But I do want to speak to the underlying bill briefly. This amendment implies somehow that it's all about President Trump, and it's not. This bill is about fashioning a process that works well in both parties. And I want to thank the gentleman from Kansas for making sure in the amendment that now has been agreed to this amendment, that it does it better. I might note that when Mr. Schmidt was Attorney General, the fact is 16 states came together, 16 attorney generals. That represented all the people of 16 states. There was nobody left with the burden because through their elected process, they had created someone to represent them. They had pre-agreed to someone to represent them. What we're trying to deal with in the underlying bill is that one person who doesn't like something that's been done can go to one judge and affect an entire workforce nationwide. Those people may not choose to object. They may be quite pleased with it. They haven't been given a chance to be a party, and they have not voted for representation. I suppose, in collective bargaining, you do vote or you do ask for representation, but they don't. This is one individual going to one judge. So I would say that when this becomes law, it is very possible that we will see more states' attorney general on behalf of two or more states choosing to go through the process to quickly get a decision from a three-judge panel, quickly go to an expedited event at the Supreme Court, and we will see swift justice, not justice I like, not justice the other party likes, but justice is defined in our Constitution. So I'm going to oppose this and ask that we simply move on to the underlying bill, which I think now is something that even the ranking member has given it a low but passing grade. And with that, I yield back.
Gentleman yields back. The question occurs.
Mr. Chairman.
The gentleman from New York is recognized.
I yield to the gentleman from, I move to strike last word.
Gentleman is recognized.
I yield to Mr. Johnson.
I thank the gentleman for yielding. The gentleman from California argues that this legislation is not put forward in response to supporting Donald Trump's recklessness and unlawfulness, but I submit that the timing of the filing of this legislation is particularly coincidental. It was just filed last week after these various courts have issued rulings against the Trump administration, and I don't think any such legislation has been filed in the past that would take or rip away from federal district court judges the ability to issue injunctive relief that applies across the board, more than just to the individuals before the court. So this is a revolutionary, extreme proposal that has been put forward. It has not had benefit of a hearing, where we can hear from all of the various sides, if there are any. I think there's not too many folks who want to rip away the power of federal district court judges to issue injunctive relief on a broad scale. But if there are, we certainly would need to hear from them, hear their arguments, and find out what is it that compels us to have to change the law, a law that has a part of the law that judges, in other words, judges have been issuing nationwide injunctions for at least a century. And for us to change on a dime that practice, that part of our jurisprudence just doesn't make good sense to me at this particular time, particularly since we've not had a hearing on the merits of this legislation. So for those reasons, I ask that the findings that I'm asking to be included in the legislation be included, that this amendment pass, because it's important that we have a record of why this legislation is being passed at this particular time. And with that, I'll yield back to the gentleman from New York.
No, yield back.
Gentleman yields back. The question is on the amendment to the amendment in nature as substitute. All those in favor say aye.
Aye.
Those opposed, no. No. In the opinion of the chair, the noes have it, the noes have it, and the amendment is not agreed to. The question now occurs on the amendment.
Mr. Chairman.
Oh, I'm sorry, there is someone else.
Yes, there is.
For what purpose does the gentlelady seek recognition?
Mr. Chairman, I have an amendment at the desk.
I thought you might.
I
The
told you in advance.
I know you did,
See how
very
courteous
kindly.
I am?
Okay, the clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1526.
The amendment, I would unanimous consent, the amendment. The gentleman reserves a point of order. Ask unanimous consent, the amendment be suspend the reading, and the gentlelady is recognized to explain her amendment.
Thank you, Mr. Chairman, and also the sponsor. I'm surprised that my colleagues on the other side of the aisle are now trying to prevent federal district court judges from issuing nationwide injunctions. They had no issue with such injunctions 2 years ago when Judge Kuzmarek issued a nationwide injunction against the FDA's approval of abortion medication, an injunction riddled with errors and which the Supreme Court later reversed for lack of standing. Last Congress, as the chairman knows, I introduced a bicameral bill, the Fair Courts Act, which would have helped reform our justice system so cases in which plaintiffs seeking a nationwide injunction would have to have their case heard by a 3-judge panel instead of a lone judge. So 3 judges as fact finders, similar to the amendment that we saw for the AGs. My bill would have addressed strategic litigation by plaintiffs filing in specific districts, knowing that their case would go in front of a friendly judge who would give them the outcome they wanted, along with facts that may not be true. Unfortunately, Republicans then did not think a single district court blocking an administration action nationwide was a problem. Now that district court judges appointed by presidents of both parties, including President Trump, are blocking the new administration's actions, it's suddenly a problem for my colleagues on the other side. However, I still think the problem of judge shopping is in this bill and could be abused. So my amendment would ensure that when a plaintiff files a suit in a district court, there's no more than a 25% chance that it would go before any particular judge. I think we can agree that litigants should not be gaming the system by picking their judges in advance. And my hope is that my colleagues on the other side of the aisle will support my amendment. And I'm happy to answer questions about the details. In many judicial districts, this wouldn't be a problem because they do have random selection. But in this particular small Texas federal district, you only get one judge. And lots of people have been going there to seek his wisdom or lack thereof.
Will the gentlelady yield for question?
Yes.
So if you would explain a bit further when you said there would be no more than a 25% chance of any particular judge drawing a particular case, can you explain how that happens, especially if there's just one judge in that district?
Right. So what would happen is, and this is on, it starts on line 10 of page 2, where you're talking about low population districts. And so a low population district is a district that doesn't have enough judges to ensure the 25% probability. So you would use then, starting on line 18, judges from adjacent districts. So so that you would have enough judges to be able to have this randomness. And, you know, this may not just apply in this one Texas district. It could apply in areas where there would be a particularly liberal judge. So this is completely agnostic as to who appointed you. It's just about not allowing that kind of judge shopping.
Can you yield for one other question?
Absolutely.
The judge in Judge Kazmarik's case, the lone judge in a low population district, would that judge also be part of the lottery so they could be drawn?
Correct. So that we would not be making sure, we would not be saying that that judge could never hear these cases. We're just saying that basically any litigant couldn't be assured of having that judge, so that they may consider filing in a different venue.
Okay, now would you connect what you want to do, which seems perfectly logical and compelling, to the general subject we're talking about, which is nationwide injunctions?
So my bill that I introduced last Congress actually is very similar to how we do it in North Carolina, that if you're going to have a statewide injunction on something that has to do with a fundamental constitutional issue, not necessarily a statutory issue, but a constitutional issue, that there would be a 3-judge panel, and that it would actually have to be politically diverse and geographically diverse in order to be able to have a constitutional issue have that full injunctive relief. But that bill was not given a hearing. Again, we had a Senate sponsor, Senator Wyden. Had we passed it, you would have been able to benefit from it this year. So see, you should have taken it up in the court subcommittee last Congress. I think we could have gotten bipartisan support. But here we are today, and I would appreciate the members supporting this amendment, and I yield
Would the
back.
gentlelady yield just for a moment?
I yield even though I'm over my time.
Well, I can't see that right now. I'm looking at you. I believe the gentleman's going to insist on his point of order as not germane. But if he does, because the parliamentarian has whispered to me that that happens to be the case, that it won't be, what I will tell you is I support the concept of it. If you look at the patent pilot bill, which ancient years ago, it specifically tried to do the same thing to prevent somebody grabbing a bill. And we have repeatedly reminded the people in both East and West Texas, where one judge keeps grabbing bills, that that was an intent we wanted to. So I'd be happy to work with the gentlelady on a separate bill. I will guarantee a hearing in the subcommittee, because I do believe that forms of randomization that ensure that you can't forum shop, particularly in smaller areas where it naturally happens. Absolutely, the gentlelady is right and is well within our committee's jurisdiction. So if I failed to serve you properly in the last Congress, I will tell you, notwithstanding a vote here today, that I will serve you better this Congress.
Well, I appreciate that. I do believe that this amendment is germane, because I was thinking about just simply substituting my bill from the last Congress in this and was told other parts were not germane. So I do believe that this amendment is germane, and I would appreciate a vote on that. However, should I not prevail, I surely would love to introduce this as a bill.
I thank the gentlelady. Now does the gentleman continue to assist on his point of order?
The chairman has uncannily read my mind. I was just wondering if I could get a palm reading, too.
And if the parliamentarian will rule. Does the gentleman,
Yes.
I already did that. The gentleman,
Am I recognized, Mr. Chairman?
the gentleman is recognized to explain germaneness.
Thank you, Mr. Chairman. The gentlelady's amendment would introduce material beyond the scope and purpose of the bill before us, and therefore it violates House Rule 16 of Clause 7. I yield back.
The gentleman yields back. Does the sponsor of the amendment wish to be heard on the point of order?
That's fine. I disagree, but I'm not going to appeal, because I'm going to get my whole own hearing in the court subcommittee.
That is true. Okay. I'm now prepared to rule. The gentlewoman's amendment does not satisfy the subject matter and fundamental purpose test. Therefore, it is not germane and is ruled out of order. but the promise continues. Who else seeks recognition? The question is on the amendment to the amendment, I'm sorry, next page. There we go. The question is on adoption of an amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor, please say aye. Aye. Any opposed? No. In the opinion of the chair, the ayes have it. The ayes have it. Hold on. Sorry about this, I'm having a bad time with the button. The question is on favorably reporting the bill as amended. All those in favor of that bill, please say aye. Aye. Any opposed? No. In the opinion of the chair, the ayes have it. The ayes.
Seeking recorded vote.
The gentleman requests a recorded vote. The clerk will call the roll.
Mr. Jordan? Mr. Issa?
Aye.
Mr. Issa votes aye. Mr. Biggs? Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Knott? Mr. Harris? Mr. Onder? Mr. Schmidt? Mr. Schmidt votes aye. Mr. Gill? Mr. Gill votes aye. Mr. Baumgartner? Mr. Raskin? Mr. Raskin votes no. Mr. Nadler? Mr. Nadler votes no. Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Mr. Garcia votes no. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes no. Mr. Moskowitz? Mr. Goldman? Ms. Crockett? Mr. Jordan? Mr. Jordan votes yes. Mr. Van Drew votes no. Mr. Van Drew votes yes.
The gentleman from Washington.
Mr. Baumgartner votes yes.
I was wondering who else sought recognition. There are so many.
Mr. Gooden votes yes.
The gentleman from Missouri.
Mr. Onder votes aye. Ms. Hageman, you are not recorded. Ms. Hageman votes aye. Mr. Fry, you're not recorded. Mr. Fry votes aye.
The clerk will report.
Mr. Chairman, there are 14 ayes and 9 noes.
The ayes have it. The bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill is adopted as a single amendment in the nature of a substitute incorporating all adopted amendments. The staff will be authorized to make technically conforming changes. This concludes the committee's business. The markup is adjourned.